Either here or present business with the appellate division. Draw near with your attendance and shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have more than 4.5 hours of argument time requested, so only ask for the time that you need, not the time that you want. If we have further questions, we will keep asking them. People versus Harvey Zimmerman. That is submitted. Tashawanda versus Ladarius is submitted. Orstein versus 301 East 78, appellant. I'm sorry, what?
3 and 2.
Respondent? 3, 2, and 5. Crone versus Rays, appellant. Mark it submitted. People versus Ba, appellant.
Requests
5, 1, and 5. Thank you. French versus New York State Department of Labor. Appellant? Is the appellant not here? Do you two wish to submit? We do not have any questions. Do you wish to submit? Do you also wish to submit?
Yes.
Okay, thank you. McAuley versus New Line Structures, appellant.
Appellant 5 and 1, please.
Respondent,
Respondent 5, please.
5, 1, and 5. Zang Lun Law Firm versus Zang Lun Law Firm, appellant. I'm sorry, what? Okay, 5, 2, and 5. People versus Curtis is submitted. Yuso versus Sewell, appellant. Respondent? 5, 1, and 5. Noak Medical versus OSK, appellant.
Appellant 8 and 2, please.
Respondent?
5,
I'll give you 6, 1, and 5. Rivera versus FNS Contracting, appellant.
Appellant 8 and 2, please.
Respondent, 8 minutes as well.
6, 1, and 6. And if we have more questions, we'll keep asking them. Parker versus Trustees of the Spence School is submitted, and Bay versus City of New York is submitted. So the first case being argued is Orstein versus 301 East 78. Take a seat, relax. Go ahead.
Good afternoon. Catherine Everett for the appellant D'Onofrio. The plaintiff's errata sheet was both procedurally and substantively defective. Not only was it not signed, not subscribed before a notary, there were no reasons for the changes sought. It was not returned to the party who issued it, which was the City of New York. It was issued in the middle of her deposition, 700 days later, and it made substantive changes to her testimony.
What's the basis for your argument that it made substantive changes to her testimony? Well, how did it make substantive changes, and how is it inconsistent with any of the prior testimony she had actually given about how the accident occurred?
When she was specifically questioned about where she fell, a photograph that she produced was given to her. She marked with an X the area that she fell.
Okay, it's undisputed that the place she marked was not what she described, but is there any other instance you can show where her testimony was inconsistent in how she described where she actually fell?
Because she talks about flying over to the area that she now claims that she fell. She was specifically asked, was there a plate there? And she said no. And the area, it was even talked about how far the distance was from where the area that she marked with an X was, and then the area that she marked with a circle that had a plate where she wound up landing, where the tar was. And then at her deposition, she makes substantive changes to it and talks about the fact that the reason why she made these changes was because she was tired, and that the 50H hearing was very long. But when you look, it was 57 minutes, and this woman is a businesswoman. She's got an MBA. She works for a cybersecurity company where she sells and makes sales all over the globe. There's no reason why she would be too tired and could not answer the questions adequately in 57 minutes. There's no reason why she improperly marked an X because she was tired. She marked the X because that's where she fell, which was in the concrete, and not on the plate and the tar that she changed her testimony to.
At the 58, she does say that she tripped on the tar and the plate, and I agree that her testimony is not a model of clarity, and the trial counsel for your client will have a pretty good cross-examination. But is it really contradictory from her rata sheet?
I believe it is, because when she was questioned at the 50H, and the questioning attorney realized that there was was not clear, the questioning attorney went back to make it clear that she tripped where the cone was, flew in the air, and fell on the area where the plate and the tar was. With the questioning that I believe you're speaking of is when she said, yeah, she was onto the tar. And then when it was clarified, she meant, yes, I tripped where the concrete was, and I landed, which was a distance away, on the plate and the tar area.
Thank you.
For the respondent, Lorenzo Tasso with Melillo and Grossman. I think that the testimony at the 50, well, first of all, I don't think that at the time limit that they're arguing, the many of the things that they're arguing apply in this case. But on regards to the changes, she did start stating throughout the whole deposition, she was asked specifically, throughout the whole 50H hearing, she was asked specifically where she fell, and she said the tar and the plate. Even before that, in her notice of claim, it clearly stated the place where the accident occurred was the tar and the plate.
Counsel, wasn't the defendant prejudiced by only receiving the errata sheet at the EBT?
Well, according to her prior attorney, Mr. Spinell, he gave that errata sheet the day he received it, which was March 27th.
Okay.
And that's the day she sent the errata sheet to him. He specifically, in his emails, which are before the court, he specifically told her how to make the corrections and where to put them on a correction sheet.
But those emails referenced corrections relating to her injury. They didn't necessarily reference any corrections regarding the location of the accident.
As she explains in her affidavit, when she was sent, if you look at the timeline, although the emails are, because as they were sent, they may not be in order, but if you look at the date and the time, the first email was on March 26th, and that's where he sent the transcript. And as she states in her affidavit, when she received that, she started immediately reading it and started to see some problems. And she responded to him, okay, I see the problems. Then after that email, he said, put the changes on the errata sheet. Now there's a whole course of emails that were after this, after the changes you're saying about her injury. There were changes, there is email transmissions regarding where should she make the changes. And he says, put it on the errata sheet. And then he notices in another email, okay, it's not there. There's no errata sheet. Put it on a correction sheet. And he tells her what to put on the
Actually,
correction
she
sheet.
said errata, what and where is it, right? So
Right.
she didn't even know what he was talking about.
Right. Where is it and what is it? Right. He didn't tell her what it was.
Right.
How would she know? She's not an attorney. How would she know what an errata sheet is? She
Yes.
if it wasn't included with the transcript, it wouldn't be present.
Yeah, okay, but you don't dispute that she marks an X on a photo, and then she looks at it later and says, no, that's not right. So she corrected herself, right? But it's not like she said, oh, I fell because of the rain, and then later said, oh, I fell because I got hit by something, right? It's just a matter of where exactly she fell. And that is always subject to cross-examination, and someone can hand her the that photo at her at trial. So other than that, though, she does testify consistently that she fell on the tar and the plate, right?
Yes, I do agree. I think the issue that.
So, I mean, yeah,
Which really
right.
should be decided.
Right,
Shouldn't decide the issues.
right. Okay.
Thank you.
I refer the court to this court's recent decision in April of 2024 on the same
No, that's a
issue.
different case completely. That's a different theory of liability, there's a lot of different things that go on there. This is a woman who looks at a photograph and says, oh yeah, I guess around there, and then later looks at it and says, no, I didn't mean that. I meant closer. At the same time she's testifying, at her 58, I fell on the tar and the plate, right?
But those questions, then she goes back and she specifically asked about it. And the fact that there was
all right,
the cone
let's
there.
go through it. Let's
The
go through it.
fact-
You
the
want to go
fact
through it?
that
At her
there's a cone
58,
there.
did you land on the metal plate? I did. I mean, yeah, okay, so she says
She
I was
landed on it,
mistaken.
right, but that's not where she tripped. And the fact that the
No, that's
cone
not
there-
where she X'd. That's the only thing. That's not where she X'd.
But the cone, that whole line of questioning about the cone, and the pictures show the cone is nowhere near the tar.
So
and the-
was the cone, did anyone say that the cone was there at the time of the accident?
She says it was not.
Right,
which
exactly.
makes
So
it
later
even-
on, you'll look at one moment, give me a moment. At one moment, months later, you're looking at a deposition and there's a big cone there, a caution cone, which, I mean, if I was looking at it, I might think, oh yeah, that must be where I fell. But then you think about it later and realize how far it is from where you said you fell, which was the tar and the plate, and you correct it. And you have the absolute right to cross-examine her on that. But it's not a situation where someone changes their theory of liability or changes how the accident occurred or any of that, right?
But she is changing her theory of liability because where she falls determines which defendants are potentially in the case and which
where
aren't.
she-
And that's a big difference.
So where she fell was a part of the notice of claim, right?
But I
First
represent
paperwork.
D'Onofrio. I represent the construction company. So where that fall is a big difference. And going back to the fact that the cone is an issue, she was specifically testified. There was multiple times where she could have realized this is a sophisticated woman with an MBA. This isn't someone that didn't understand the questions.
Thank you very much. The next case is People versus Ba.
Good afternoon. I'm Catherine Martone on behalf of Mr. Ba. The verdict convicting him of second-degree robbery is against the weight of the evidence, where the prosecution failed to establish that he shared the separately charged co-defendant Romeo Carrion's intent to steal the complaining witness's backpack.
How do you get around the preservation issue, counsel?
Our claim that the verdict is against the weight of the evidence doesn't require preservation. So this court must, in fact, reach it on appeal if raised. On the prosecution's own theory, Mr. Ba and his teenage friend, Mr. Carrion, did not plan to commit a robbery when they boarded the Uptown train at 1 o'clock in the morning. They were just drunk and being
What
rowdy.
about the evidence that is in the record, though, that the victim made 10 requests to get back his backpack and they refused to give it back to him, that he tried to push the victim out of the train while the friend remained inside the train with the victim's backpack? Why aren't those evidence sufficient under these?
Because weighing against that evidence is the fact that, for instance, just to cite one piece of evidence weighing against that, Your Honor, is that in the immediate aftermath of the incident, when you would expect the complaining witness's recollection to be more reliable, he told Detective Gayton, he reported that at 116th Street, which is the tail end of this incident, which started around about 34th Street. He reported that Mr. Boss said about the backpack that he was supposedly trying to steal, "Whose bag is it?" He reported Mr. Boss
You know, the
making
jury,
that
this is,
statement.
the jury heard all this evidence. This was
Yeah.
a jury trial.
Yes.
It was, even if there was some evidence that helped your client, there was also credible evidence that there was an intent. Isn't that exactly what it, why would we take that away from the jury in that circumstance?
Because we're saying here that the jury just didn't weigh the evidence properly, and that, in fact, this was a close case. The jury deliberated over a period of 2 days. They asked for readbacks regarding the complaining witness's testimony
That all indicates that they thought about it.
and acting in concert. Yeah, or it could mean, Your Honor, that it was a difficult case, and in the end, they just didn't get it right because they didn't give enough weight to, for instance, the
So it sounds
evidence.
that they balanced the different factors, the different evidence, and came to a
Judge,
determination.
I guess the point here is that it's your job, you're required on appeal to reweigh it and consider whether the jury did in fact get it right. You are in fact sitting as a 16th or 13th juror, You are doing the reweighing yourself, and you have to decide whether the jury just got it wrong. And there,
But what evidence is there that the jury got it wrong? When it's a credibility thing, when they're assessing what the complaining witness is saying, and the complaining witness is cross-examined about what he said and did not say in the immediate aftermath of this incident, why should we disturb that? What is there to say that they got it wrong?
What I'm pointing to here, Your Honor, is the fact that throughout this incident, Mr. Ba's conduct was wholly consistent with just trying to defend his friend in the midst of this ongoing altercation with.
Well, I understand that's your argument, but the complaining witness testified that Mr. Ba made statements like, don't touch my friend, this is our bag now, go home, that he squared up when he asked for the bag back. Those two instances about squaring up when asking for the bag back and saying this is our bag now, that's enough.
Okay, sure.
If credited.
Right, but there is also weighing against that evidence in the case, the complaining witness's statement to the police right after the incident that Mr. Ba said, "Don't touch my friend." The complaining witness's statement did not reflect any threat at all to stay away from the bag. That's a telling omission that suggests his testimony over time
Even
evolved.
though when the police got him, the defendant and they had the bag.
His friend had the bag.
They had
at
the
all-
bag.
all times, Your
Right.
Honor. Mr.
And they were
Ba
together.
never-
When they got off the train, they had the bag.
The friend had the bag. Mr. Ba was carrying on with his friend. This is two teenagers. Well, my client was about 20. These kids are drunk. They are on the train late at night. His juvenile friend makes a spur-of-the-moment decision to pick this bag up off the floor of the train where it fell after they had been already in a fist fight.
Counsel, just to close the circle about, I'm sorry, to close the circle about preservation, what's your best case on that? Because, I don't know, I thought the Court of Appeals has said it has to be preserved. You do have to be specific about how
No, and
what's your best case then? Tell me.
I would say that that's People v. Daniels, Your Honor.
And did that overrule People v. Gray?
I'm sorry, I misspoke. It's Danielson. It's People v. Danielson at 9 New York 3rd, 342.
Okay, thank you.
Thank you very much.
Good afternoon, Your Honors. Hunter Barron for the People. I do want to say just at the top, my understanding is that while this court can reweigh the evidence, the jury is granted great deference in their verdict and their decision. And here they were presented with overwhelming evidence of defendants' threats and his efforts to push.
When you say overwhelming, what do you mean overwhelming? So from what I read, it was the complaining witnesses' statements, right? There was no video, there was nothing else, there was no admission. Is
Yes,
that what
Your
you're
Honor.
considering overwhelming?
It was overwhelming in that The victim testified, the testimony was credible, and it explained at various opportunities the victim gave the defendant and his accomplice several opportunities to give back his bag. He asked for it repeatedly, and the defendant responded with only threats, with a fighting stance. When
The victim explained his failure to tell the officers the statements that that counsel now questions.
I'm sorry, could you?
Did the complaining witness at trial testify about his failure to tell the officers about the statement that he now alleges that the defendant made that show his intent to steal?
He was questioned about his prior statements, but I'm not sure he gave an explanation for any supposed discrepancy between those statements. The defense, on their defense case, introduced they questioned two police officers about prior interviews. But again, the jury.
So let me just ask you, right? And that wasn't an inconsistent statement. It was the argument is it wasn't a complete statement. It wasn't like when he was interviewed right after the event, he said, no one tried to get anything from me, and then changed his testimony. Is that right?
That's correct, Your Honor.
So it's a different thing to say it was sort of like a lie on one hand and not on the other. That wasn't said right after the event, but it was said at trial.
Yes, Your Honor. And my understanding is that for an omission to be an inconsistency by omission, there's various strict requirements for that to fulfill, and I don't think those were fulfilled in this case. But even putting that aside, the jury was presented with all this evidence, and it was clear that the defendant was given various opportunities for them to give this bag back, and he responded with threats, trying to push the victim off the train when the victim was trying to signal the conductor for help, saying, "Help! These guys have my bag." And that's when he responded with force. And
Counsel, how do you respond to your adversary's position that preservation is not required? My understanding is that under Gray, the argument that evidence is legally insufficient preserved only if the court's attention is specifically directed to the alleged error.
That's correct, Your Honor. The legal sufficiency claim requires preservation. However, my understanding is weight of the evidence does not.
It's not, okay.
So unless your others have further questions. Thank you.
Thank you very much.
I just would like to briefly circle back to the testimony about the fighter stance when Mr. Ba allegedly put himself between the complaining witness and Mr. Carrion. And the complaining witness's testimony describing what Mr. Ba did points out the whole problem with the prosecution's case, because he said, when he was describing it, that it was as though Mr. Ba was saying with his body language, "Don't touch my friend, don't get your bag." And what the prosecution needed to prove here beyond a reasonable doubt was that Mr. Ba's intent was, in fact, "Don't get your bag." And because it's ambiguous on this record, and we can't say what it was, whether it was the one or
Couldn't
the
the jury
other.
have determined what his intent was when the complaining witness testified that Mr. Boss said, "This is our bag now"?
I think that there was testimony that Mr. Carrion said that at some point, but I don't believe, Your Honor, that that statement was ever attributed to Mr. Ba.
Thank you very much.
Thank you.
McAuley versus New Line Structures.
Good afternoon. May it please the court. I represent the plaintiff appellant Matthew McAuley in this matter. I believe this is a straightforward error demonstrating a clear misunderstanding of the labor law that seems to be kind of plaguing the bench in the lower courts because it's all I do at this point.
I'm sorry, what did you just say, the last thing you just said? I didn't hear the last thing.
It's all that I do now is pretty much the labor law, and I've seen a vast misunderstanding of the law and the case law interpreting it throughout the judiciary on the trial court level. And in this case, this is a witnessed accident. There's proof of the accident. This is not one of the cases that we see in the New York Post where we're making something up that didn't happen. He went and got treated for it. We have pictures of his head.
So your adversary makes much of the distinction as to whether it was a witness accident or he was actually involved in taking the plane down. Does it make a difference?
Makes zero difference. But again, why would there be any sort of incentive to lie about this? It makes no difference whether he was taking part in it or not, as set forth by the expert and also by the case law, that when an object requires securing for the undertaking, it triggers the ambits of Labor Law 240. It requires the safety devices of the type enumerated within the statute.
Is what happened here, can it be considered as an inherent danger of the job that was being performed, taking down those planks?
What I believe Your Honor is referring to is whether this is a usual danger at a work site as opposed to an elevation-related hazard.
Correct.
And that has been dealt with, this very scenario has been dealt with by the Court of Appeals, and this court in Walensky is the Court of Appeal, is the transitionary Court of Appeals case where there was a 10-foot pipe, 10-foot pipes that were standing next to him that fell over and struck him. At that time, the court applying runner said the fact that it was standing on the ground does not take this out of a 240 of an elevation-related hazard.
What about the argument that this is akin to a demolition type situation where the job is to remove it and there are inherent dangers in removing it, and that was the job to remove it?
And the job to remove it is, just the fact that it's your job to remove something doesn't take it out of whether or not it required securing for the purposes of the undertaking. And
how do you distinguish the demolition type cases where we have sometimes held that there's no liability because that was their job to demolish it and take it down, which is similar to this situation? So how is this distinguishable from those cases?
Right. Well, the one thing is, there are a couple of things. Number one is that we have an expert. They had an opportunity to get an expert also, and they didn't. So our expert said that this is the type of thing where normally you would either take a chain to attach it to another part of the wall that's not being removed, or you would use a scaffold or something to prop it up as it's being removed from the wall. That's number one. Number two, it's because of the weight and the height. That's what differentiates it. So that's basically it.
Okay. Any further questions? Okay, thank you very much.
May it please the court, William O'Connell, Goldberg Segala for the defendant respondents. We should win this case because this was not a gravity-related accident, and also because there are tribal issues of fact in the case. Your Honor, I believe referred to them.
The panel was 1 foot off the ground, roughly. Would you agree with that?
The
panel, when it was being
yes, it
removed.
was.
Okay, your point seems to be that when his coworkers removed the panel, the force was them using a crowbar, essentially, and it popped out, right?
Absolutely.
But didn't it pop out and down, meaning gravity was working on it as well?
Yes, in part.
Game over then.
No, I don't think game over, Your Honor. According to the Court of Appeals, it can be tangentially affected with gravity, and that's not a 240 violation. And if you look at the two Court of Appeals cases here, Walensky and Fabrizi.
How could this be tangentially created by gravity, where it's a long item that fell down because of its heavy weight? Isn't that inherently gravity related?
Again, it's our position that...
How could gravity be tangential to that?
Well, because they were using crowbars to pull it out towards themselves and to remove it from the wall. And it did remove from the wall.
But it fell because of the force of gravity that made it fall to the ground. So why isn't that gravity related?
And in the cases in my brief, there are frequently cases where they're sawing a tree, they're sawing a subway thing, and it pops up because of the pressure and the stress, and then it falls down. That has a little gravity in it too.
What about the absence of an expert or some testimony to refute the plaintiff's expert? Because the plaintiff's expert said that this was a load that required securing and that there were safety devices that could have been used to secure it. So what was your response to that?
My response is this. We could have gotten an expert, but in our position, the real defense in this case is what we've already been talking about. The Walensky, because
it wasn't necessary or even logical to secure this because it had to be taken off the wall with crowbars. For example, plaintiff's expert said you would move a scaffold up against the wall to keep it there and then still somehow pull it off with a crowbar. I mean, it makes no sense.
The plaintiff's expert clearly testified that there were ways to secure it while it was being removed, while acknowledging it was being removed. So why wasn't there a response to that testimony, which seems to be a prima facie showing that some kind of device was required and was available that could have been used?
It's our position that a device wasn't required because it was being removed. And as one of your honors referred to before, that's the whole purpose. Walensky says that if it's being demolished, and in our case, to me, removal would be the same thing because the risk is the same.
Except we have someone who actually knows something about this and not just a lawyer making an argument saying you do need something. So you can't discount that and say, gee, I'm a lawyer and I know better than this expert on this issue who says there are things that you can do to make this safe, and they didn't do it. There are things. So you can't just deny that and say, well, it's our position because we lawyers know better than that expert.
Understood, but my point is that the expert is not qualified to say that this is...
Did you argue that at all? No, not at all.
It's our position he's not qualified to argue that this is not a gravity-related accident under Walensky or that it was a logical thing to do. He can say we should have secured it, but it's the legal argument that I'm making that he is not qualified to make. And I still think it stands here under Walensky and Fabrizi. If you look at both those cases, they suggest we should win because, number one, these things were being removed akin to being demolished. And secondly...
The guys are on a scissor lift.
Yes.
And they're removing these louvers.
They were.
And one pops out that the expert said there are things that could have, devices that could have stopped this louver from popping out, coming down on the plaintiff's head, right?
Generally, yes.
No, that's what was...
I didn't deny it. I just said it's much more conclusory than you're giving it, I believe, credit. But to me, it was just a very straight statement. You could use devices, and he names them all from the statute.
Okay, so then why didn't you put in an expert that's saying anything to raise an issue of fact as to that? As far as we're concerned, all we have is the only person who knows anything about this who's saying that your client should have but didn't.
It's our position that there are also credibility issues, which I think Your Honor has already referred to, but I still think you can make the legal decision that because this is under Walensky, this is not a this is a demolish type case, that you could say it was not necessary, or there's a triable issue of fact, and there are cases that hold triable issue as opposed to definitely labor law doesn't apply.
Thank you.
Thank you, Judge.
I just have 2 quick points to make, and I'm glad I kept it to 1 minute. Number one, they did not raise the demolition issue at the trial court level because it's something that I didn't even address it in my appeal because they didn't raise it at that level. This is something that they've come up with since then because there is no case. And if you look at all the cases cited in their brief, there is not one case that stands for the proposition that when something is being taken down, it doesn't need requires securing for the purposes of the undertaking. And I'm quoting to Outar, O-U-T-A-R, in the Court of Appeals famous case where they said that it's not just when something is being raised or lowered. It's got to be, it also applies, 240 applies also when it needs to be secured for the purposes of the undertaking. And not one of their cases say it, and they didn't argue it at the trial court level. The trial court came up with its own theory and said, and asked the attorney who was arguing the case, he said, well, if it was on ice, if the thing was on ice, it could have come across horizontally and struck the plaintiff because the unrefuted evidence of the plaintiff was that he was standing 5 to 10 feet away from the panel at the time the accident occurred. So the court said, well, it could have been on ice and then slid across and hit him.
Counsel, thank you very much.
Thank you, Your Honor. Have a good day.
Zang Lun Law Firm versus Zang Lun Law Firm.
Good morning, Your Honor. My name is Philip Zang for the plaintiff and appellant, and respondent make a motion, pre-answer motion, and the law court granted, and for the cause of failure to state cause of action, and we believe, according to the CPLR, and the law court should accept the fact as alleged are true and accord plaintiff the benefit of every possible.
Counsel, to interrupt you, it seems to me you've pled some intermingling of the two, the parent law firm and the other law firm here in the States, but how was the ignoring that you allege of the corporate form used to hurt the plaintiff, the defendant, pardon me?
The parent law firm, I remember that in 2013, I come to this very building to ask for 3 copies of certificate of good standing. The parent firm, they know that the foreign law firm cannot be a member of a New York law firm. So they decide that later one of their Beijing-based partner to be the partner of the new firm. So there's a lot of discussion how they should organize this, the plaintiff, okay, the firm.
My question was how was the abuse of the corporate form that you're alleging used to hurt the plaintiff?
I will not say, because when they initially incorporated, they just follow the local law, because this is not a typical business, this is a law firm, okay? So they have to use this form. So I think that because of this, they just try to dodge their responsibility in relating to this cause of action, So as we say in the brief that the parent law firm, they completely dominate the respondent, and also they use this domination to commit wrong and fraud. And I think the most important issue is here that the law court they do make a mistake about the ownership between the parents and the respondent, and we have the record at the hearing show that the totally overlap of the ownership of the two firms, and we did not specifically, allege that in the complaint, and we are all business corporate lawyer, we are inexperienced, so we did not do that. But at the hearing, it's very clear, we tell the judge that the ownership between the parents and the respondent is totally overlapped. And so they take that, I think the parent company take advantage of this, and they totally, just do not show up, this is the game they play. And they wanted to resolve that, they wanted to get the benefit of doing business in New York, but do not have any responsibility, whichever, if this case is dismissed, I think in the future, maybe all the similar foreign law firms, they will just do as they do, because even though they have a subsidiary in New York, they're not reliable. So I think, back to your Honor's question, I think this is kind of, they do by the action. It's kind of thing that I think should not be allowed in this jurisdiction.
You have time on rebuttal, okay?
Good afternoon, Your Honors. May it please the Court, I am Kerry Kaltenbach on behalf of Defendant Respondent Pro Se, Jungla New York LLP. The decision and order of Judge Cohen dismissing the plaintiff's first amended verified complaint as to Junglan New York LLP should be affirmed for two reasons. First, whatever issues the plaintiff had with the law firm in China, the plaintiff has failed to and cannot adequately allege an alter ego claim against Junglan New York LLP. As Judge Cohen found, the points he was just making about overlap of ownership, it's not alleged in the complaint, and I could tell you here it's simply not true. There is none, there is no, and has never been.
You were at oral argument, weren't you?
Yes.
You conceded that you do have some branding overlap, correct? That's a quote.
We're both Junglan law firm, correct.
So what does that mean?
For purposes of alter ego, it means nothing.
Well, don't you also share partners, share websites, and share the same emails?
I'm sorry?
Don't the two entities also share the same website and as well as emails?
Yes, both are the emails are at junglan.com. But for purposes of alter ego, that's really not an issue. I think for purposes of imputing a conflict of interest, there's case law that's relevant. But the plaintiff hasn't cited, and I'm not aware of any case law that's a basis for.
The same officers, the same. You're saying that has no relevance?
No, there are.
Of course it does. The same officers, the same space, the same email addresses. They may not be enough, but they're not irrelevant.
No, there are not the same officers. There's not the same space.
Isn't that what the law firm alleged, that you have the same partners in both firms?
It's not alleged in the complaint. He raised that for the first time at oral argument.
Without any affidavits, right?
Affidavits from the
From someone who would know, right?
I'm sorry, affidavits
From a person with knowledge as to whether or not the partners were the same at both firms.
Right. He hasn't submitted affidavits, and we haven't submitted affidavits. But I could tell you now, there's no overlap in ownership. There's no overlap in space.
I want to focus on the argument that it wasn't used to, whatever form was used wasn't used to commit any wrong.
Right. He makes allegations in the complaint. There was some kind of medical fraud, and there was some kind of immigration fraud. He doesn't allege that Junglan New York, the party for whom I'm here today, engaged in this.
But is there any allegation that supports that the alleged misuse of the corporate form was somehow used to deceive the plaintiff in this action?
I really don't follow that argument. He can explain that. I really never completely understood that. I suspect that maybe when he was...
So isn't that your argument why it should be dismissed?
Oh, yeah, it is part of the
That's what I'm
reason.
asking you what your argument
I'm
is.
sorry.
How are you addressing it?
Yeah, I'm sorry, Your Honor. Yeah, whatever...
It seems like that's the cleanest argument for you, so I thought you'd want to focus on it.
Whatever argument he has about immigration fraud or medical fraud, it doesn't apply to us. That element is not alleged. And, that's just another basis for dismissing it.
Thank you very much.
Thank you, Your Honors.
Your Honor, I think, when this Chinese law firm, they incorporate the plaintiff, okay, they did aware that they increased the possibility that it will be sued in New York. And that's the reason that this is among the top-tier law firm in China. This is the last one incorporated here in New York. So I don't think that when they incorporate the plaintiff in such a way, or maybe later when they reorganize the respondent in such a way, I don't think they are purposely say we want to commit fraud. Okay, but this is just they want to circle around the rules because it's a law firm business. It's just not like a typical business. Human being got to be a member. Okay, but when this developed, when this
somehow, counsel, you have to make ZL New York responsible for a 2013 oral promise that was made in China. So you're doing, reverse.
I think the respondents, they totally know that we have such an arrangement with the parent company, and by
But ZL New York was not a party to that agreement, that 2013 oral agreement.
Yes, but I think the significant event is about the reorganization of the respondent. The reorganization of the respondent is that team joined the firm. When they join the firm, they know that there are this kind of existing arrangement with the appellant. So at that moment, I think the key word is the reorganization of the respondent. They change their name and let another Beijing-based partner to be their,
So if the parent firm does not pay its malpractice insurer in China, then ZL New York is responsible to the malpractice insurer in China?
I think that they have the whole package of insurance, not only.
I'm just saying, like, are they responsible for everything ever done by the parent in China? Or any malfeasance by the parent in China? Are they responsible for everything? They're the same entity?
Yeah, I think they should, because they get benefit for what their parents doing. Okay, without this, they will not be in
Thank you
business.
very much.
Okay, thank you, Honor.
Yuso versus Sewell.
Good afternoon, Your Honors. May it please the court, Chet Lukaszewski for petitioner appellant Yuso. Your Honors, the Court of Appeals said in these cases we use common sense. They said it's an accident when something is sudden, out of the ordinary, and unexpected. If you're going to apply common sense to this situation, I don't know how anyone can reach the conclusion that going to a concert and being rendered deaf as a result isn't an accident
Counsel,
with those.
Isn't the question whether loud music at a concert is something that's unexpected in some way, or that it's an incidental aspect of being at a concert, that if you're at a concert, there's going to be loud music? So why is it accidental?
Because, Your Honor,
Because what's accidental about it?
there's levels of loud. We've all been to concerts. Everyone has been to concerts. People don't get rendered deaf.
But
There's
where
an
have you
element of loud when it becomes injurious.
Where have you alleged that there was something special about this concert that was out of the ordinary in terms of the noise level? This was unlike any other concert, and that something different happened at this concert.
Your Honor, I just think that is proven by the fact that this has never come across the pension board's desk. Every week, every month, for years and years and years, NYPD officers are sent to these concerts. There hasn't been a single case where one has been rendered deaf. I made the analogy in my reply brief.
Does that work against your argument that it's an accident?
It's an accident when the music that he's stationed in front of this speaker takes such a spike, such an injurious.
You allege that there was a spike in the music?
That's the acoustic trauma. That was the medical evidence that was presented. That was the conclusion of the medical board, that it was an acoustic trauma suffered during this event.
An acoustic trauma, that doesn't mean that there was a spike in the acoustics, does it? It could be that it was just loud.
No, Your Honor, that's not how the science worked. We presented the case law that showed, and Your Honor, even say it's over the course of the concert. Still, there's not a single case on point where this has happened. There's nothing in the archives of the pension fund. So if you're doing the common sense analysis, if officers are sent to these on a regular basis, and this has never happened, it's like the Gakel case, Your Honor. Every officer goes through scooter training. The one time something happens that scooter accelerates and creates a permanent disabling injury, this ended this person's career. He was a lieutenant. He had 17 years on. He was going to make 20. He was going to keep going. He's assigned to a concert detail. We all think you're going to a concert, there's going to be loud music. Sure. No one thinks you're going to walk out of there deaf. It was a spike in the music for a long enough period of time to render him deaf, to end his career, to end his police, his work, his pension. All of this was affected.
He got a disability pension, doesn't he?
Right, he had a
He
disability.
didn't end his pension. He gets a pension.
It cut into his pension significantly and did end his career, Your Honor.
So how about, oh no, for sure.
Right.
But how about Hull versus Kelly?
Which was
How
that, Your
about-
Honor?
That's hearing loss sustained by performance of crowd controls at parades and
Yes,
concerts, Murphy versus Bratton, if he was at
Right.
a firing range.
Can I
and-
respond? Those are over time. Those are career assignments. That is what takes it out of the sudden element. This is a point in time. They can specify the
But
point in
he
time.
says he was there for several hours with loud music.
And we presented the science that it probably occurred within a minute, give or take. But even say it was over several hours, it's a day in time. Every other case, Hamble, Cole, Murphy, these are assignments that took months and years. If you're at the firing range for years, that takes the sudden out of it. This is a moment in time that is specified. One day, one night, one instance in his life where he was forever changed.
Counsel,
That's
is
the
there
whole
any
purpose of the accident
evidence-
statute.
Is there any evidence that there was anything about, other than you're just surmising, is there any evidence that anything was unusual about this concert? Did anyone else, I mean, there's obviously no evidence that anyone else suffered hearing losses.
That's
So
the
what-
unusual part. He
what's
walked out deaf, Your Honor. How was that not unusual?
What was unusual about the concert?
That the concert wasn't unusual. The spike in noise volume during his location that rendered him deaf. No one else was rendered deaf. No other officer has been rendered deaf. He is the outlier. He is the accident. He is the out of the ordinary, unexpected person who was here when this speaker went so loud that he was never able to hear the same out of that ear again. This is what this is for, this statute. The odd occurrences
Thank
that
you.
change people's lives.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Martin Rowe for respondents. We respectfully ask this court affirm the decision of the court below. Simply put, there was no precipitating accidental event here, as Your Honors were indicating.
Let me just ask you, the counsel said that he alleged in the petition that there was a sudden burst of noise that caused the deafness. Do you agree with that?
I do not. There is no indication in the petition or the record
Anywhere, right? There's nothing in there in the petition that says at 10 o'clock, the noise or whatever, at some point, the noise went so loud, right?
That's correct. I would
The
point.
petition says that there was loud noise over several hours.
That's correct. So the record.
Is there anything in your adversary's medical records that indicate that the deafness was brought about by a sudden noise or increase in volume?
No, Your Honor. I believe the kind of confusion here comes with the nature of the diagnosis as the sudden idiopathic deafness. The confusion is it's not whether the onset of the illness was sudden, it's whether the cause of the illness was sudden. So the fact that it appeared to him as a layman that, oh, I'm all of a sudden deaf, yes, that seems sudden, but it's as Your Honors were indicating, the several hours, which is as alleged in the petition. And as the record at page 28 indicates, in counsel's follow-up correspondence with the board, he indicates again that it was the presence at the concert over several hours that caused his injury. So
Characterization of it as being idiopathic means that is an unknown cause, correct?
yes, Your Honor. So the record does clarify that the reason for that indication is because, as a layman, he did not, at the time he presented to his doctors, make the connection between the concert and his onset of deafness. So scientifically, yes, idiopathic means without a cause, but
Is that fatal to his claim that he didn't immediately identify the concert as the cause of his deafness?
no, Your Honor. The fact that he didn't identify it doesn't render the causal question moot in any way. Again, we would point
And here the board was split on that, right?
Yes, Your Honor. It was a 6-6 tie, which led to the upholding of the ODR, which Your Honors pointed out earlier. He did receive his ODR pension, which not as much as he would have liked, but that's particularly what it's for in these, what they refer to as incidental accidents as opposed to accidents.
And so, and when Dr. Van Buda said that loud noise at a concert could cause hearing loss, that doctor didn't say it was caused by a sudden spike in music, right?
No,
There's nothing in the record that says that his hearing loss was caused by a sudden spike in music.
There is absolutely nothing indicating that. This was a routine concert assignment with an unfortunate outcome, but again, there's like the cases this court routinely issues, cases Court of Appeals routinely issues, like a Pratt, where you have an officer who's a fire officer who's running down the sideboard of a truck, jumps off the truck, but his foot lands in the pothole. There's not that extra thing here, that pothole, that unexpected sudden event. This was a several hours long concert duty that unfortunately for Officer Yuso led to permanent hearing damage, but that's not an accident. As my opposing counsel said, we're using common sense here. If I sit in a chair for several hours and my back hurts, that's an incident. If I sit in the chair and the leg breaks off and I fall and injure my back, that's an accident.
Thank you.
Thank you.
Your Honors, I would just point you to page 295 of the record, where the scientific support for what an idiopathic sudden hearing loss entails. The point of being there for 6 hours is there is ample opportunity for that spike in volume to cause such damage to occur. But if that's going to be dismissed by the court and we're going to talk about sudden, I would refer the court to the cases where something was found not to be sudden. It's where someone was assigned to a shooting range for 4 years. It's where someone was assigned to a firehouse for a majority of their career. It's where someone had repetitious, over weeks, months, years exposure. This was a moment in time, whether you want to say it was 1 minute or whether you want to say it was 6 hours during a concert. He still walked into an assignment. There was a traumatic hearing injury that altered his life, ended his career. He walked out deaf. That just doesn't happen when you go to concerts. If it did, and respectfully to the lower court, the PD would know about it and they would start assigning hearing protection like they've done at the firing ranges. They haven't. This is the rare, unexpected event that deserves the protections of the statute.
Thank you.
Thank you, Your Honors.
Noak Medical versus OSK.
Good afternoon, Your Honors. My name is Alex Bowie. I represent the appellant, OSK. We are defendant and counterclaim plaintiff below. We challenge the Supreme Court's finding of a waiver in its summary judgment decision. We challenge the Supreme Court's finding that that waiver continued until June. And we challenge the Supreme Court's finding that the June 8th offer that my client made did not satisfy the Nassau Trust test. I think there really are two differences between the way the parties view this situation. The respondent claims that we have not shown that we were misled, that the statements that we point to by Windels, the lawyers for Noak, did not mislead people on the OSK side of the transaction. We were the sellers, Noak was the buyers, Windels was representing the buyer, and what we pointed to was my client asking over and over again to set a closing date, and that did not occur.
Break down the arguments, because it's two separate arguments we're talking. We're talking about whether initially there was a waiver and then subsequent events. So if you could break down what you're discussing in terms of the two events and start by talking about whether there was an initial waiver, which they were granted summary judgment on. So why was that incorrect?
Because it did not take into account the communications between the parties at or around the time of the expiration date. And waiver is an equitable doctrine. It protects against lulling a counterparty into a false sense that you won't enforce a right.
Let's talk about the specifics. So that date was January 2021, right? That was the expiration date. Wasn't there evidence in the record that after that date, your client indicated that it was still willing to go forward with the agreement, even though there had not been a closing that occurred on that date?
Yes, there was.
So why wasn't that a waiver by your client's own statements that were in the record that they were still willing to go forward with the transaction, even though it hadn't closed on that date?
Because they were not being told the truth about why the closing was not occurring. My client said that it was willing to go forward as long as they were making genuine efforts to close the deal. There was also, he said, we were willing to go forward as long as they were working in good faith and making progress. But what happened was over and over, my clients asked to set a closing date. They were told, oh, we're waiting for the TLC, which was not true. And there was omitted from those
And also,
statements.
is it my understanding that, is this correct, that each medallion had to have a single purchaser? And they had to be LLCs?
Each medallion needed to have a single
And you
purchaser,
fault them for
except
not-
for
Oh,
two
sorry.
that were what's called a mini fleet.
Okay, all right, but you do fault them for not setting up those LLCs promptly, correct?
They did not even try to start setting them up until after the expiration date, and they never revealed that to my client. So my issue is whether you look at this as a partial representation that was deceptive because it omitted material facts, or whether it was a special facts type of circumstance where my client was reliant upon the other party in order to find out information about what was going on. They were not being told the true story. Therefore, their decision to allow the work to continue was not knowing.
What does the record show about their reliance on whatever was represented to them? I mean, to me, it seems like the record was kind of like they were just hanging, your client was just hanging loose and waiting, didn't care that much. And so that formed a waiver as far as they were concerned. They didn't feel like they had to get these LLCs set up pronto.
Well, but that's countered by my client continuing to ask, when are you going to close? We want to close. Why?
Right, but that just shows that they still wanted to close after that date passed. There's never any indication that it was a make or break date, that they were willing to keep working with them. And let me ask you about the later date where you sent out the
June 8th offer.
the due date. Was that enough time you gave them in terms
was
of
from
how it was played out?
The time in that draft agreement, which was emailed on June 8th, was obtained from Windell's, the lawyers for Noyak. That's what Windell said, that's the date when we can close. So my client said, fine, you can have until that date, just sign this, and after that,
it's the
it's
signed
a different deal.
Yeah, go ahead. What was the time period that they were given to sign it?
They were told that they needed to sign that day.
From the time from when they received it to the date in which they had to sign off on it? Was it not 3 hours?
Well, there's an issue with the time because of the fact that we've got different time zones, Your Honor, but I do believe that to the close of business perhaps, but the evidence is that there was no response to that offer. And in our view, that offer was a sufficient opportunity to perform with a reasonable amount of time.
Is your requirement that they sign off before close of business on an amendment that they're receiving that day? Is that reasonable? Is that a fair amount of time for them for you to require that?
Well, it was a simple amendment with respect to the time period under which the other party had to perform under the terms of the original agreement. It was simply, you've got until the 16th. And that was from the lawyers for that party. So I'm not really sure what was complicated about it.
Well, weren't the prices raised for each medallion?
No. The opportunity to perform was under the terms of the original agreement through the 16th of June. After that, it says, if you want to go forward at that point, we're going to talk about a higher price.
Oh, so close within 8 days, and if you're not able to close in 8 days, you have to pay more.
Exactly, if you want to go forward with the transaction.
Thank you.
Good afternoon. May it please the court, Brendan Goodhouse from the firm Cuddy & Fetter for the plaintiff respondent Noyak here. The waiver issue, it's important to step back and look at what the court actually held here. It was a fairly limited holding. Both parties moved for summary judgment, found issues of fact on pretty much everything requiring trial. The one thing she said could be determined of a matter of law was just that the January expiration date was waived.
What about the argument that they were deceived when they said that, it didn't have to close on that date? That was based on your client's deception.
First, dispute the deception, and I can get into that specifically, but all the communications they're talking about post-date January by several months. I don't see how you can possibly say there was anything other than a waiver of the January date. There's nothing in the record at all about closing.
So let me, okay, fair enough. let's assume that the January date was waived. What did you do to close these between January and June?
There's a lot of work going on.
Let me hear.
Sure.
Like what?
Sure. There was several medallions, it was found out in January, still needed UCC.
So when did you sign the contract?
October.
So between October and January, you didn't find out anything like that? The
No,
first time you found out was after the closing date?
On some issues, yes. Not many others. I mean, work started right away. There's billing records in the summary judgment record. There's also a extensive timeline that goes through this. This was a lot of work. There were 39 medallions. Frankly, it was a much bigger transaction than anybody at Windell's had handled. It was a way bigger transaction than anybody at OSK had ever handled. And there was a lot of work that went on. Now,
so when you find that out, why don't you speak and say, we need to renegotiate the date that we're getting this done by?
Because the parties were in frequent communication, you got to the January date, right? And you went past, and nobody had said anything about
Also, you
setting
paid a substantial down payment already, right? $10K
Correct.
per medallion.
Correct.
So that's in the
$390, yes. So they had made a substantial down payment. They were all in. They were committed. And if to the point, Your Honor, I'm not going to get up here and say everything was perfect.
No, but what I'm saying to you is they keep asking you, when are you going to close? When are you going to close? When are you going to close? Now it's June. It's already 9 months later, and you're not even close.
That's not true at all. If you look at the timeline here, but again, I feel like
Wait a second. So then why didn't you just sign on June 8th the documents that said we're ready to close?
What happened, Your Honor, on June 7th, the OSK folks got on the phone. They said to Windell's, transaction is terminated. The market's changed. You have to pay $90,000 if you want to buy medallions. They send a follow-up email saying that. Colin Dougherty, who wrote that email, in an affidavit he submitted on the preliminary injunction and then was shown and reaffirmed at his deposition, made clear that was a termination. And from that point on, OSK would only transact if Noyak signed an amended agreement. The June 8th deal, he said, was an example of that. Now, if what OSK had done was said, okay, guys, this has gone on long enough. You got until the 16th. You got 1 week. You got 2 weeks, whatever. We would then have a debate about whether that is a reasonable period of time, whether that is notice and a reasonable period of time.
You mean reasonable from your first date, which is you're supposed to close in January. So the question is whether at some point between January, which is the date in the contract that you're bound to, and June, which you haven't done anything to close, or you haven't, let me not say that, you haven't closed, whether at some point the other party has the right to say enough is enough, close now.
They have the right to say enough is enough. They don't have the right to say close now. The law's really clear on this.
I don't think, look, and I've looked at the same law. We've both been practicing this a long time. So I don't agree with you that there is not a point where a party can say enough is enough, close.
There has to be a reasonable opportunity
and
to perform.
And you're saying between January and June wasn't your reason?
Well, they have to give notice and a reasonable opportunity. It doesn't become an option.
What about all the emails in February, March, April, May, June? When are we closing? When are we closing?
Your Honor, we're talking about 3 text messages over the course of 5 months.
What about those?
And at each time, hey, are we going to be able to close this month? And there's an answer. And then they don't. And then if OSK had wanted to, they could have said, that's it. We're setting a deadline. And they continuously chose not to. And Hugh Cameron in his testimony was clear, we didn't want to. And the reason they didn't want to, again, and this is an issue for trial, it's not summary judgment, but there's plenty in the record, is that the market conditions were terrible. They had an incentive to keep the deal open. The market changed drastically at the last week of May. They terminated the contract. They said we needed more money. And just really quickly on that June 8th piece.
No, your time's
up. Okay.
Thank you very much.
Just very quickly, I think really what we're talking about is the rigidity with which the Nassau Trust test should be applied. It is an equitable doctrine. The way that they're looking at it is really it's kind of a tripwire and you've waived, and then you have to go through some very formal kind of withdrawal in order to withdraw. My people were trying to withdraw. Secondly, on the $75,000 argument that the market improved and all
Well,
of
what
a
do you
sudden-
say to counsel's argument that your guy said that the deal is done? And he did say the deal is done. It's not that we're going to have this deal, it's going to be another deal. What do you say about that?
Well, it was an amendment to the original deal, and it was specifically both in the text of the amendment itself and in the covering email, an offer to proceed under the original agreement. It was explicit. But this idea that we did this when we did because of the fact that the market price was going up is just wrong. We offered to sell them the medallions at $75,000 over and over again after June 7th.
Thank you very much. Rivera versus FNS Contracting.
Good afternoon. May it please the court. My name is Mitchell Corder, Eppinger, Reingold and Corder for the appellant Carmen Rivera. Your Honors, I'm here to suggest to you that this is a clear-cut textbook case of the doctrine of res ipsa loquitur. I'm also here to suggest to you that the court
Counsel,
below-
you'd concede that the Court of Appeals has said it's very rare to grant a summary judgment motion based on res ipsa loquitur evidentiary proof, right?
Yes, Your Honor, you are correct, but very rare does not mean never. And
Well, how do we get around Torah then? Because Torah's got facts that are pretty close to this case. How do you distinguish Torah?
I distinguish it by saying this is a case that specifically involves the erection of a fence, and we are alleging that there was what has been referred to as a wind sail or a mesh that is unique to the establishment of this fence and that was erected exclusively by the defendants. So the unique fact pattern here puts this in a very distinct category.
Well, but it was wind operating on the sidewalk shed in Torah, too, that was alleged to have knocked down part of it.
Right, but that was a sidewalk shed. This is a fence.
Yeah.
And I would draw the distinction that the wind velocity, at least as far as our expert is concerned, suggests that had that mesh not been there, this fence would not have toppled.
I know, but the defendant's expert says that the wind velocity was very powerful and unexplained, or unexpected, I think.
Yes, we're claiming that that is speculative, notwithstanding the defendant's expert saying that this downdraft or this Doppler of 55 to 60 miles an hour, he has been
How
presented.
can we disregard that testimony from the meteorologist that says that why isn't that sufficient to create an issue as to what caused the fence to fall over? Which would take it out of res ipsa.
Because he's presented as a meteorological/weather expert. And in his report, he specifically says that he is such an expert, and therefore he believes he is qualified to say that because of this downdraft, that fence collapsed. What I am suggesting is that if he is in fact a meteorological expert, he is absolutely not a fence or shed expert. He's not a physical engineer.
Of a question of fact that based on that level of wind gusts for the trier of fact to determine whether that type of wind gust would be sufficient to knock over the fence?
It would only be sufficient for a trier of fact to determine it if the trier of fact accepts the expert's report, which we are suggesting is speculative. In his report, he does not reference in any way, shape, or form, not a single solitary word about the deposition testimony of the defendant's witnesses, and most importantly, he does not reference whatsoever the YODOC specifications for erecting this barrier. And it's attached to the record. Those specs specifically say, you should not put a wind barrier, a mesh barrier, anything that could create such a danger. And if in fact you do it, and the wind velocity is north of 45 miles per hour, you can anticipate that there will be injury to property and to person. So I am suggesting that the court below erred not only in accepting this speculative testimony of this witness, but if I am correct, and I'm suggesting that I am, of course, but if I am correct, and this is not an admissible affidavit by this expert, they do not have a defense to our case, that this instrumentality, this fence, was within the exclusive possession of the defendants. They erected it, they maintained it, they controlled it.
No, counsel, what about just the general testimony that these fences can fall without negligence? Res ipsa requires that this accident would not have occurred except for someone's negligence.
Correct.
And the expert says fences can fall because of high winds having nothing to do with negligence, right?
Well, that's what the expert said.
Right. And you don't, and right. So you're asking us to disregard that general proposition that fences can fall without someone being negligent?
No, I'm asking the court to disregard this expert's opinion.
Right, but isn't that one of the elements of res ipsa, that it has to be able to happen in the absence of negligence? That's the primary requirement for res ipsa.
Correct.
So if you're acknowledging, as my colleague just stated, that this could happen generally in the absence of negligence, then that undercuts applying res ipsa as a matter of
I'm not acknowledging that it could happen in the absence of negligence. We're claiming it was negligence. And as a matter of fact, the defendants...
That's a different thing.
So, that's not the res ipsa doctrine. That's the basic tenet of it. That you have to, for it to apply, you have to show that this is something that happens in the absence of negligence. What?
Right.
Does not occur, I'm sorry, in the absence of negligence. Okay,
I'm sorry, is there a question posed to me at this point?
no. Thank you.
Good afternoon, Your Honors. Elisa Zeltz for defendants' respondents. I just wanted to explain very briefly about the Bow Echo, because one of the plaintiff's arguments has been that the expert's report is somehow speculative. And just to explain why the court was correct in finding that these unforeseen, very strong wind gusts occurred at the time of the accident on July 25th at 6:05 a.m., and the accident occurred in the vicinity of 375 Pearl Street. And this is illustrated in some of the diagrams, some of the material that's attached to the expert's affidavit. So what he found is that there are rainstorms, thunderstorms that were forming in eastern Pennsylvania at about 4:30 in the morning. Those thunderstorms are very disorganized, and they're starting to move towards New Jersey. At the same time, at about, and this again, this is all in his affidavit, at 5:43 in the morning, now remember the accident happened at 6:05, at 5:43 in the morning at Newark Airport, there's a cumulonimbus cloud.
All these things, these meteorological things were happening, but did he consider the specs for Yodoc barriers in his report?
He did not specifically consider the specs. What he found, he looked at the video, and what he found is that there are these extremely strong downdrafts of wind in the area of 55 to 60 miles per hour at the time of the accident, and that was sufficient to, and you looked at the video also, which is part of the record, that was sufficient to cause this fence barrier, to cause the fence to knock over. And he explained because a fence is, it's like a sail, and it can catch the wind, and so it could fall over. Plaintiff actually helped me with my argument because he said, he pointed to the manufacturer's warnings, which say that you shouldn't have this mesh if wind gusts are expected to exceed 45 miles per hour. Expected to exceed 45 miles per hour. Well, these were unforeseeable winds, not expected, and our experts said that it's going to be that those wind gusts were 55 to 60 miles per hour. So that shows that it was unforeseeable wind gusts that caused this wind, it was, even the manufacturer would have expected this fence to fall over if you have wind gusts at 55 to 60 miles per hour.
Counsel, your adversary pointed to the fact that the weather reports relied on by your expert, that they were not certified. Does that matter to the case?
It does not matter at all, and I would like to address that. Thank you for bringing it up. Number one, this is not an argument that was raised in the court below. Number two, it wasn't even raised in his appellant's brief. He raised it for the first time in the reply brief. So it shouldn't be just considered for those reasons. Number three, even the court decides to consider it, it doesn't matter because there is an exception for when an expert can rely on out-of-court statements, and that's the, it's the professional reliability exception. And what our expert relied on was all official weather data from government sources. And under CPLR 4528, those weather sources constitutes prima facie evidence. And we also do cite cases in our brief where the courts found, the First Department courts found, that the defendant established its prima facie burden of demonstrating a particular weather condition, relying on the expert's affidavit backed up by the climatological data. Just very briefly on, I don't want to get too, go into this Bow Echo again too much, but just I want to make sure your honors understand it. There are these photographs of Doppler radar images on page 270. And what you'll see is this Bow Echo is a band of rain and thunder showers. And there's a tremendous wind that causes the band to curve. And most of the strongest wind gusts are at the apex of the Bow Echo. And what happens is the Bow Echo in this case was moving from Pennsylvania, New Jersey, to the tip of southern Manhattan. And what our expert found, a professional certified meteorologist, looking at, among other things, these Doppler radar images, which you can see for yourselves, that the apex of the Bow Echo was at the location of the accident when it occurred, and that's when you had these tremendously strong, severe, damaging winds. And the Bow Echo, while it's not a common term for us, you could look it up on a YouTube video and it'll explain exactly what our expert has said and what I'm trying to explain here today.
Thank you.
Any questions? Thank you.
With all due
I'm going to attempt to ask my question correctly because I realized I was getting it backwards before. The question I wanted to ask is why isn't there an issue as to whether the fence can fall down in the absence of negligence due to an unusually high wind gust? And why didn't they, at a minimum, their expert established that there was an unusually high wind gust? So if we accept that their experts testifying that it's an unusually high wind gust, why isn't there enough to create an issue of fact that this fence fell down not due to any negligence, but due to an act of nature?
If the court does in fact accept their experts' testimony.
Not about the fence, but just that there was, even if we just accept the testimony that there was an unusually high wind gust, and accepting your argument that the expert didn't really say anything about the fence, why isn't that enough by itself to create an issue of fact?
Because the Yodoc barrier specs specifically say that you should not put this mesh or this fabric.
But that's a different question than whether or not res ipsa applies. Res ipsa only applies if the accident could not have happened without negligence. And if there's an expert that says this accident could occur without negligence, then all we're saying is that res ipsa doesn't apply. You still have everything else. You have all your negligence claims. You just don't get that extra oomph from res ipsa.
I understand that,
Or
and
you
I'm
get
trying.
it before the trier of fact and not before us. In other words, you maintain your ability to ask for the charge of res ipsa below, but we can't give you summary judgment here on res ipsa.
No, I understand that. I'm simply asking this court to revisit the decision below.
Thank you very much.
All right. Hear